Okay, hi. Here's the next video. Let's spend a few minutes talking about pleading, and here I'm going to focus pretty much solely on plausibility pleading. All right. You go into some of my other videos, you can hear me talking about answers and admissions and denials and all of that stuff. But right now I'm going to spend a few times talking about 2 minutes talking about some of the more difficult concepts that might show up in the exam. And that's going to be plausibility pleading. All right. In the time of Conley versus Gibson, all you had to show to state a claim was to show fair notice to the defendant and additionally show that it was possible for the plaintiff to prevail. In other words, the plaintiff needed not to plead himself or herself out of court. As Conley said, complaint should not be dismissed for failure to state a claim unless it appears beyond doubt the plaintiff can prove no set of facts in support of the claim which would entitle them to relief. All right, so as long as you don't plead yourself out of court, you might be fine. You couldn't be completely conclusory, but as long as you didn't say any facts that would mean you must lose, you might be okay. So for instance, like P sues D for battery, it says right on the face of the complaint, the battery happened in grade school in 1965. All right. Well, then the statute of limitations defense is right there on the face of the complaint. The plaintiff has pleaded itself out of court. Twitball still requires fair notice to the defendant of who's suing whom for what, right? What the nature of the claims are. That's called fair notice. But now is kind of boosted the standard from possibility pleading to plausibility pleading. All right. As the court says, you have to have enough factual matter, except it is true. The state of the claim is plausible on its face. Well, what does all that mean? Well, one thing the court says, see, I have pretty graphics here. Possibility pleading is no longer enough. The court says, unhelpfully, that probability need not be shown. You instead have to show plausibility. Well, that's about as helpful as saying, how much does baby bear want to eat, right? No, not too much, not too little. Not very helpful. So let's move on to something that's hopefully a little bit more helpful. What you do with Conley, what you do with Iqbal and Twombly, or Twitball, is, there we go. You deal with competing inferences. So a Twitball fact pattern is going to be presented when you have a complaint that gives some facts but doesn't give facts for each and every necessary element of the claim. All right? There's some facts, but there's a hole in the facts. So the example I use with my JD students is Meg sues Brian for hitting her car while they're driving down the road. So Meg's driving down the road and she's hit by a blue Prius, but she never sees who's driving the car. All right? And her allegations are something like this. Brian, I'm talking Brian Griffin, right? Brian drives a blue Prius. Meg was driving down the road. She was hit by a blue Prius, but she didn't see the driver. And then she asserts, therefore, Brian was negligent. Well, there's a problem here, right? She's alleged that somebody has breached a duty because they ran into her, right? She never alleged that Brian was the driver. Instead, she's asking us to infer from the facts that Brian, one, owns a car, a blue Prius, and second, she was hit by a blue Prius, that therefore Brian was the driver. We have a hole in the facts, right? Now, under Conley, at least that's arguably, it's a stretch, but under Conley, that's arguably enough because, it's possible that Brian was the one who did it, right? She hasn't pleaded herself out of court, and if we make a reasonable inference that it was Brian that possibly hit her, she might state a claim. Under Twitball, that's not going to be enough. And here's how we do it. The first step is to separate well-pleaded facts from legal conclusions. So you take the complaint I just gave. Brian owns a blue Prius. A blue Prius hit Meg's car, and that's it. Now the question is going to be, is that enough to state a claim as plausible on its face that Brian hit Meg? we've separated the legal conclusion that Brian's negligent from the facts that Brian drives a Prius and that a blue Prius hit her car. All right? We separate the facts from the conclusions. Now we need to ask whether the claim is plausible. Well, the court tells us some language that's not real helpful, right? They tell us use judicial experience and common sense. Well, whatever that means. I think that means use your life experience and common sense to think which inference is more likely. And here's what I mean by inference. Let's go back to the scenario. We know that Brian drives and owns a blue Prius. We know a blue Prius hit Meg. We assume those pleaded facts to be true. All right? There's no allegation that Brian was the one that was driving the car that hit Meg. So we make an inference, right? And there's actually competing inferences, aren't there? What are the two inferences? Inference number one, Brian hit Meg. Inference number two, some other schmo driving a blue Prius hit Meg, right? Now we have to use common sense and life experience. Based on the facts given, which one's more likable? Or likable? Likable? Liable. Which one's more Oh man, too late today. Okay, given our life experience, given the facts, Brian drives a blue Prius and the blue Prius hit her. Oh, I know I said likable. I was trying to say which one is more likely, and I tied it together with liable. So it's likable, liable and likable became, yeah, okay. Between those two competing inferences, Brian was driving that blue Prius and hit her, and some other person was driving the blue Prius and hit her. Which one is more, wait for it, likely? What do you think? Based on life experience. He owns a blue Prius, someone hit me with a blue Prius. Which one's more likely? He was the culprit, or was somebody else? What do you think? Someone else. Why? Why somebody else?
There could be thousands of blue Priuses on the road.
There's thousands and thousands of blue Priuses on the road. It's possible that Brian was the guy that hit Meg in his blue Prius. But it's also possible it was somebody else. In fact, amongst those two inferences we're making, the inference that it was somebody else is more likely than the inference that it was her. Now, what Iqbal says to us when we need to make those kind of inferences, the court tells us that the claim is plausible only if the inference of liability exceeds the one of non-liability. So we need to have more facts pleaded so we can find it sufficiently believable. In other words, that any inferences tilting towards liability are more likely than the ones tilting against not liability. Now, personally, I think that's a Seventh Amendment violation, but the Supreme Court says that it's not, so, I don't get a vote on the Supreme Court, so I guess that they're right in that that's what the law is since, right? You heard me, John Roberts. So I think that's what you need to know about Iqbal, right? There's a hole in the facts. You got to make inference, all right? Which inference is more likely? If the inference of liability exceeds the inference of non-liability, then the claim is plausible. If the inference of non-liability exceeds the inference of liability, then the claim is not plausible. And the irony here, I think, is it's a lot easier to understand this after 3 years of law school, once you've taken evidence, maybe trial ad, all of that stuff. It's really not that hard a concept, but for a first or second semester law student, it's vexing. All right, so I have more stuff on the website about pleadings and the like, but I'm going to stop this video here. Thank you.